Good day. My name is Jim McLaren. I'm a family court attorney from Columbia, South Carolina. And I've been at this practice for about 35 years now. And I hope to share with you today what I've learned through those 35 years of practice on the subject of attorney-attorney relationships. In this business, the most important asset you have is your reputation. There is no more valuable asset that you have or will exercise or could do harm to in your practice than your reputation. That is your currency. That's what you have to spend. That's how you will earn your living. Without a reputation, you cannot effectively represent your clients. Not once in your practice should you allow your reputation to be scarred or diminished by anything you might do on behalf of a client, whether that's your interaction with a client, other lawyers, or with the court. What we do for a living is a very hard and difficult practice. It's very rewarding, but what you do day to day is very emotionally charged, and you cannot slip in how you handle things. You cannot slip in your relationships with other lawyers. Take a moment and Google lawyer civility, and you will see a plethora of writings around the country that primarily focus on what judges expect from lawyers, what judges do not like about lawyer conduct, what grievance committees do with lawyers who behave badly, and what our clients expect of us. And what you'll find is a growing concern that lawyers are not civil with one another. In many quarters, lawyers will say, well, my clients expect me to be tough. They expect me to be uncivil. Well, that's not what they expect, and that's not the best practice in terms of what you can do for your clients. When you become uncivil, your ability to advocate for your clients and ultimately convince a judge, which is your ultimate responsibility and goal, will be diminished if you do not know how to behave civilly and appropriately. There are fundamental areas I'd like to talk to you about today. One is, throughout this presentation, I'd like you to focus on the different approaches you might take as a lawyer. I'd like you to focus on what your default approach is, who you are. Each one of us wears a different suit of clothes. It's difficult to be like somebody else, but you can do things to enhance who you are and what you feel comfortable in, what skin you live in. And it also will help you deal with conduct that you don't like, lawyers who are uncivil to you, and how you go about dealing with that type of conduct. In your dealings with lawyers, you want to be known as a lawyer that's civil, pleasant, businesslike, prepared, has good judgment, and works hard for the client. Our business comes not from advertising, it comes from our reputation. That means that when a judge sees you in the courtroom and has the opportunity to refer, and they do refer, or they do mention names, you want to be the one that gets the case. When you get a case from another lawyer, they're sending that case to you because you have demonstrated skills as a lawyer that we all want to endeavor to have. They come from other clients. And I suggest to you that these type of referrals do not come to you because you're uncivil, uncouth, boorish, intemperate, bullying. That's not where it comes from. It comes from being a good lawyer. There are lawyers in the community that do not behave civilly. They send letters that confirm conversations that never really happened. They're inaccurate. They're intended to document a file with inaccuracies. You have lawyers that begin every hearing with an attack as opposed to a focus on the issues. They become cases where you are the object of the aggression. I suggest to you that that's not the way to go about it. in the American Academy of Matrimonial Lawyers, we're a pretty tough bunch. We all know how to advocate for our clients, but we've learned to be civil. We had a lawyer in our community who I knew very well, and I'd practiced against him probably for 25 years. And he became very, very unpleasant, and I decided one day I would try to do something about it. And I found that lawyers have a sensitivity to being told what other people think about them, or worse yet, say about them. If judges raise their eyebrows or look away when the other lawyer is putting on theatrics, lawyers are impacted by that. They're motivated to change. I took this lawyer aside and I said, would you mind if we talked for a while? I want to talk to you about something personal. And we went to a private place and talked. And I told him we had been friends for a long time, and I had no motivation to have this discussion with him other than to make it a better place for he and I to practice together. And I told him that the biting, acerbic, bitter, attacking conduct that came from his side of the table in each hearing or each conference was really wearing thin on everybody. It was wearing thin on the judges. And behind his back, the judges would talk about his conduct, and in an unkind way. I told him when he came into the courtroom, his client started 80% behind the 8 ball because of his conduct as opposed to the merits of the case. And I gave him some examples of things that I thought were inappropriate conduct. When we were done, he said, "Thank you for saying that to me." And after that, we had a different plane on which we operated. He might have treated other lawyers differently than he treated me, but from then on, our relationship was much better. Each hearing did not begin with an acerbic attack on me. It went to the issues. It meant being well-mannered. It comes down to, didn't your mother teach you to have manners? And that's what this is all about. It's about manners, professionalism, and being civil. George Washington said a lot about civility, and he issued a number of different things or rules by which he lived by. In your materials, you're going to see a number of those rules, and I would commend your attention to them because many of them apply today. It means doing the right thing. Let's talk a little bit about how you deal with the unpleasant lawyer other than taking him or her aside and talking about why it's unpleasant and why he or she makes life difficult. Let's talk about that. But let's also go to how do you handle it when you're not going to have that kind of dialogue. Someone once told me that when you get into a tough fight, you don't go take the fight to your opponent. You do what fighter pilots do. You become calm, you become more resolved, you stay on your game, you never acknowledge that you took a spear in the chest. And that means when the other lawyer is yelling, screaming, calling you a liar, calling your client a liar, you stay calm, you stay on your game plan. You do not attack in kind. You go back with well-reasoned arguments and stay on your game. You don't meet the challenge with words of the same kind. It doesn't do you any good. You don't win. Judges don't like to see that. So if you stay on your game and stay civil and you stay polite and you deal with each other in a tough but well-measured and good judgmental and in a way that represents that you have good judgment, you'll be a much more effective lawyer. You know, I looked through the materials that talked about lawyers who were uncivil, and it used words like intemperate, universally disagreeable, uncivil, impolite, discourteous, acerbic, acrimonious, ill-mannered, antagonistic, surly, ungracious, insolent, rude, boorish, uncouth, insulting, disparaging, spiteful, vitriolic, demeaning, rancorous. Do you want to be known as one of those lawyers? Do you want any of those adjectives to describe you? I submit that you don't. You don't need to return to with sharp comments. Stay on your game. You be the good lawyer that you are. How do you do that? If you want to set a deposition, we all know that we're busy. So you write a letter or an email or have somebody call and ask if someone is available on a particular date for a deposition. You try to coordinate things. When something can be sent by hand delivery, but you're only required to send it by mail so they get less notice, what's the right thing to do? The right thing to do is get them notice as soon as possible. When you show up at a deposition, you should show up with all the copies you need for everybody in the room, and that applies for hearings as well. It means not interrupting each other. It means not demeaning the witness or the client or the lawyer in the lawyer's presence or in the court's presence. That's just not the way to behave. Many people say that they justify their conduct because it's zealous advocacy. I submit to you that there's no such thing. In the 1983 Model Rules of Professional Conduct promulgated by the American Bar Association, zealous advocacy was not even a term or phrase that was used, nor was zeal. The words that were used were reasonable diligence and promptness. So, how do you want to be known? What do you want to be? I submit you want to be a civil, well-mannered, prepared lawyer. A lawyer who's tough, but one that's pleasant to deal with. This business is tough enough. You don't need to fall into the trap of being boorish or being ungracious or intemperate. That's not the way to win the case. Civility and courtesy goes a long way, and it is the best way to advocate your client's position.